Good morning, everyone. I'm delighted to welcome you all to this 39 Essex Chambers Breakfast webinar. As it's remote, the emphasis is on breakfast, so you can eat your cereal and croissant at the same time as getting what I think will be a very valuable update on some important procedural changes in the Administrative Court with the issue of new Part 54 practice directions, which every practitioner in this area will need to know about. And these changes come into effect from the 31st of May, so less than 2 weeks away. We've only got 30 minutes to discuss these changes, which isn't very long, but it is, after all, as long as the court expects for an oral hearing for a renewed application for permission to claim judicial review. And in the same style, that 30 minutes is, of course, meant to include time for judgment. Here, it's going to include time for questions. So could I, on that note, do encourage you, please, to take part, if you can, by asking any questions that you may have. There's a Q&A function, which is normally at the bottom of your screens on the Zoom app. And you can type in any questions. We'll do our best to get to those at the end of the session and answer them if we can. So please do write in any questions. We're also recording the session, so we hope to make it available on the Chambers website once we're done. We have two speakers today, and Rosie Scott is going to go first and talk about the new practice direction 54A and C. So that's the one dealing with general and venue. Rosie practiced mainly in public law with a focus on community and social care law, education and court protection, but with an interesting sideline in public rights of way. And then we're going to hear from Katherine Barnes, who's going to talk about practice direction 54B, urgent applications and other applications for judicial review. And she practices in all areas of public law and human rights with a focus on judicial review. She's also a very versatile practitioner and has acted in all sorts of judicial reviews ranging from energy regulation, social care entitlements, planning and environment matters, education, prisons, and the list goes on. And currently acting for a group of disabled people in a challenge to the government's consultation on its new national disability strategy. So bearing in mind how little time we've got, I'm going to hand over straight over to them and let Rosie take you through the first part dealing with 54A and 54C of the practice directions. Rosie.
Thank you and good morning. So let's leap straight in. Starting with the claim form then, the claimant must ensure that the claim form and the application notice sets out all material facts, and the claimant must make proper and necessary inquiries before seeking permission for judicial review. And this is paragraph 4.11. I should say at each bullet point, I've got brackets with the paragraph number in the practice direction. So the claimant must make proper and necessary inquiries before seeking permission to ensure so far as is reasonably possible that all relevant facts are known. And in the claim form or the statement of facts and grounds, the claimant should refer to statutory provisions which exclude the court's jurisdiction or which would prevent the grant of the relief that is sought, and should also refer to alternative appeal mechanisms that exist or could have been used. Now, none of this is revolutionary. This is all one might think good practice, but it is now made explicit in the practice direction at paragraph 4.1. Going on to the statement of facts and grounds, these must be clear and concise, and you may notice a theme as we go through practice direction 54A. I imagine that it was much enjoyed in the writing of, if we can put it that way. They must be clear and concise then, your statement of facts and grounds. Concise as possible, it's repeated. They should not exceed 40 pages and should usually be significantly shorter. More detailed specification is set out as to what the grounds should contain. For each ground, one should identify the relevant provision of law that is said to be breached and provide sufficient detail of the breach to identify essential issues. Bringing the admin court into the 21st century, you must file a hard copy and an e-bundle. Moving on. In terms of the acknowledgement of service, your summary grounds of defence must succinctly identify the relevant facts, give a brief summary of the reasoning underlying the measure. You must succinctly explain the legal basis of response. You must be 30 pages and usually significantly shorter. I did mention there was a theme. If you're making a renewed application for permission, then your request to consider should identify the scope of the renewed application. Again, you should be succinct, and you should address the reasons given by the judge refusing permission. Now, again, that might be good practice, and one would expect that, but it's making matters clearer, perhaps for litigants in person, increasing numbers as we are seeing, and it is making explicit the requirements of the court. Of course, we've got the standard hearing estimate time, 30 minutes, including judgment. If you want longer, you should request that in your application, and the parties must in any event provide an agreed estimate 7 days before the hearing. Your detailed grounds, perhaps a forlorn little plea from the court here. If you want to, a party can rely on its summary grounds of defence instead of filing detailed grounds. Good luck with that. I hope that works for some parties. If you file that, your detailed grounds must be concise again and not exceed 40 pages. The duty of candor gets its first mention at paragraph 10.1 of the practice direction. Detailed grounds should identify the relevant facts and reasoning underlying the decision in accordance with the duty of candor. My view is it's very unlikely that the practice direction is intending to suggest that the duty of candor only applies to defendants after permission when they're filing their detailed grounds. The admin court guide for one at paragraph 14.1.6 says that it's a continuing duty on all parties, but this is where it gets its first mention in the practice direction. Again, we need a hard copy and an e-bundle. This is one of the more interesting and significant changes in mine and in Katherine's view, I think. Rule 54.15 sets out that the court's permission is required if the claimant wishes to rely on additional grounds. But the practice direction goes further now. The claimant must make an application for permission to amend in accordance with Part 23. And I've set out in the brackets the key points in Part 23. One must provide notice, service of the application, and the amended statement of case must be made 3 days before the court hears the matter. And if a party has not been served with notice and with the amended statement of case, they can apply to set aside any order that is made giving permission to rely on additional grounds. The application must be made promptly, and one must explain the need for the amended grounds and any delay in making that application, which should probably include addressing why that ground wasn't included in your grounds in the first place. The court will apply, as I set out there, CPR rules 17.1 and 2, and I explain what they mean there. And the court can give the directions, further directions, if it grants permission to amend, to allow the defendant to amend its detailed grounds of defence, and so on. Skeletons. Now, I imagine that this was the part that was most enjoyed by the drafters. Skeletons are intended to assist the court by setting out as concisely as possible a party's arguments. There is a 25-page limit. Skeletons should define and confine the issues, a nice turn of phrase. They should be cross-referenced to other documents, and they should be self-contained. Now, that one is quite important. My view is that you would be allowed to refer to your statement of facts and not need to repeat all the facts in the skeleton, but it's the arguments and your reasoning and the legal propositions that should be self-contained in the skeleton. I think James might have a different view, but that might be something to argue about later. Skeletons should not quote extensively, and you should clearly identify your authorities, and that the practice direction is very clear. We're not allowed any long lists of authorities supporting a single legal proposition. If you cite more than one case per proposition of law, you should say why you're citing more. That's paragraph 14.2. If your skeleton is non-compliant with any part of these requirements, the court may return it, and you may not be permitted to refile it unless you comply with the requirements. And also the costs of preparing a non-compliant skeleton may be disallowed. So it's really worth having a look at paragraphs 14 and really absorbing those requirements. Another more significant change is that the party should agree and lodge a final bundle 21 days before the hearing. That is the same day as the claimant's skeleton is due, and it's before the defendant's skeleton is due. And to my mind, that emphasises the real need to front load your prep, and facts must be on the table at this point. If the claimant's skeleton is raising new matters, new facts, new grounds, new issues that would require the defendant to file and rely on further documents, then something is going wrong, and the defendant might quite rightly make a fuss about that. If your main bundle is over 400 pages, you need a core bundle, and the practice direction sets out requirements for what should be in the core bundle. The solicitors or the parties, if unrepresented, must certify that the main bundle and any core bundle meet these requirements, and that's at paragraph 15.1. That's an important one. 7 days before the hearing, the parties must agree and lodge an authorities bundle. So thankfully, the defendant doesn't have to agree on what authorities are required before it's filed its skeleton argument. So 7 days before the hearing, we need an authorities bundle. And particularly, we need an agreed list of issues, a chronology with cross-referencing, an essential reading list, and a time estimate. Now, these used to be in the skeletons and so would have been due more than 7 days before the hearing. But the key difference here is that these must be agreed. And so the parties will need to liaise about this and should bear this in mind. This is a more significant change for more experienced practitioners. Again, we need a hard copy and we need an e-bundle. Moving on to practice direction 54C on venue, and I have very little to say about this, which is good as I'm on 8.5 minutes with a time limit of 10. Really, practice direction 54C clarifies and continues the emphasis on the fact that courts exist outside London that can deal with administrative court matters. As I say here, it explains that the administration of the court is organised by geographical area, and it sets out what those are. One change that struck me more than the others is the general expectation is that proceedings will be administered in the region with which the claim is most closely connected. It used to be with which the claimant is most closely connected. Now, of course, where the claimant is and what connections the claimant has is still one of the factors, but it's now where the claim is most closely connected. So the issues in the claim, the defendant challenged, and so on. And that's all I have to say about practice direction 54C. And I'm at 9 minutes, so I'm very proud of myself. And I will now hand over to Katherine.
Good morning, everyone. I'm picking up with practice direction 54B, and this is the first time we've had a specific practice direction dealing with urgent applications and interim relief. And I think it's fair to say that the court has got to be in its bonnet about this issue, and there is a view that there has been historic misuse of the urgent applications procedure. And so, as I've set out there in the slide, the headline points to take away, in my view anyway, are first of all that the procedural requirements when it comes to urgent applications are now going to be strictly enforced, so you really should take them seriously. There is now greater clarity as to what exactly the expectations are in respect of form N463. And so I would suggest, first of all, whenever you are filing that form, to have a real think about whether it is justified, and I'm going to come on to that, and where you are filing it, make sure that you fill it out to the letter absolutely perfectly. And just be warned, the court's made it, well, this is already in the administrative court guide, but it's now even clearer following the DVP case, which I've cited below, which is a rather scary cautionary tale. The court is quite serious about referring practitioners that don't follow these rules under the Hamid jurisdiction, and even to the professional regulator as well. So something really to take seriously. So first of all, what you need to file to make an urgent application, and this probably will look quite familiar to you. As Rosie was saying, everything needs to be filed in hard copy and electronic format. So you need your form N463. Where you're making an application for interim relief, there is now a requirement for a witness statement verified by a statement of truth. You need to file your relevant documentation, and the practice direction is now explicit that that includes all pre-action correspondence concerning the underlying claim, but also all communication with the defendant about the urgent application. And you also need a draft order, and that needs to set out clearly and concisely the relief sought. So I'm just going to make 6 observations about those requirements, which I think are important and which come across strongly from the new regime, if you like. So the first point, your N463, as you know, needs to set out the timescale sought for consideration of the application. And what I think is now very clear is that N463 will only be appropriate for very urgent matters. And it seems, broadly speaking, something that needs to be determined within 7 days at the latest. And I should say I went to a webinar a few weeks ago given by Mr. Justice Swift, who's the head of the admin court. So I'm also kind of imparting some of his wisdom that was given in that webinar, as well as what's strictly written in the practice direction. But essentially the mood music at the court is that N463 forms are not appropriate if you want determination within 10 days, 2 weeks, 3 weeks, or a month. It is only for really urgent matters. So something that needs to be decided within a week. What has been suggested, if you need something decided quite soon, but not super soon, you need to apply for it in the claim form or in a form N244 with a covering letter explaining the time frame. And what I suspect will happen is that you will have to badger the court quite a lot to make sure that it gets before a judge within the appropriate time scale, but we'll have to see. What we do know is that, say, for example, you want directions expediting the filing of the acknowledgement of service, and you normally would say that that could be decided within 2 weeks. I would be very wary about filing an N463 to make that application now. I would have done it in the past, and I have done it without any difficulties, but I wouldn't do that now. The next point, reasons for urgency. You really need to think about this. What is it that requires immediate or very quick consideration of the claim, as opposed to the justification for bringing the claim in the first place? And this is something that was set out in the DVP case. So think specifically where the need for urgency arises. And what is clear from that same case is that, generally speaking, urgency will only be justified if there is some sort of irreversible action that the claimant will suffer unless the interim relief is granted or the claim is expedited as a matter of urgency, ASAP. So that's probably, I would suggest, the framework that you need to apply when thinking about this. And you also need to explain any delay in making the application and be warned that you may well have difficulties persuading the court of urgency if there's been really any material delay at all. You then need to set out your reasons why, not just for the urgency, but why the underlying application is justified. And again, that's likely to be quite a similar point, some kind of irreversible harm arising to see unless the application is granted. The next point I wanted to make is about putting the defendant and any interested party on notice. And again, this has always been what you're supposed to do, but the court is making it even clearer that this is the expectation and that it's really important. And generally speaking, the court will be very reluctant to grant interim relief without first hearing from the other side. I mean, I've put a suggestion, if something is genuinely really urgent and you've tried to make contact with the defendant, clearly there will be times when you're just going to have to go ahead and make the application. But I'd also think about using N463 to get directions very quickly for the filing of a response on the question of interim relief from the defendant. That may be a good way around it, so at least you can set things up for a determination on that application within a few days or a week. Next slide, please, Rosie. Next point, and I think a pretty important point for experienced practitioners, because it, for lots of people, will represent a change of practice. The court is now explicit that you cannot cross-refer in your N463 to other documents. All the information requested on the N463 needs to be provided in the N463. So it's no use. Quite often I've been instructed to draft an application for urgency in my grounds, and then the N463 cross refers to it. You can't do that anymore. So lots more work either for solicitors drafting N463s, and potentially there might be requests for counsel to draft them or at least review them. Next slide, please, Rosie. So the final point I wanted to make is about the duty of candor. And the court, again, has got to be in its bonnet about this. It wants to make really, really clear to claimants making urgent applications and applying for interim relief that they owe a duty of candor to the court. And so you are required to, in an upfront and transparent way, be clear to the court about the factors weighing both in favour and against your application. And that includes difficulties that you face in the underlying claim too. And so if I could have the next slide, Rosie, the way that that appears in the practice direction is set out there. In summary, in practical terms, what the duty of candor means is, first of all, that claimants are required, before they make the application, to investigate the matters material to that application insofar as reasonable. And then once you've done that, you need to set out all material matters to the application in the witness statement, including those which undermine the application. So being really upfront about the points against you. That concludes the whistle-stop tour of the new practice direction. They are available on the ALBA website, so I'd suggest that you familiarise yourself with the text before the 31st of May. And now I think we may have some questions.
Thank you very much to Rosie and Katherine for those excellent presentations. If I try and sum it up in 3 words, I would suggest it's concision, precision, and candor. And let's face it, all of those things can be very difficult to achieve in the challenging timeframes of judicial review, the already challenging timeframes of judicial review, and the old adage that I would have been shorter if I'd had longer springs to mind. But the court, I think we can expect the court to be looking at very close observance of these new practice directions. They've obviously been very deliberately drafted in the words and the language used, and therefore it's fairly essential to be familiar with these additional requirements, and one will ignore them at one's peril, I think. But we have got some questions in, and I think we've got some time to try and answer them live, which is probably best so everyone can see. The first is whether the changes will take immediate effect on ongoing cases, i.e. from the 31st of May. So Rosie, I don't know if you want to answer that. I've got a view myself.
I think the safe assumption is assume that they will. Certainly the 131st update says that they will come into force on the 31st of May. There is nothing to say that they won't impact on hearings that occur after the 31st of May. So I would assume that they do, to be safe.
Yes, I think that's very safe, a wise assumption. It does present some difficulties, I can understand, for ongoing cases where you may be midway through a program already of directions in relation to the timetables, to whether you then need to provide agreed chronologies and list of issues, etc. But I agree with you, it's safe to assume that one should try and meet all of those practice directions for existing cases as well, unless, of course, the directions themselves countermand what's already there. The next question is an interesting one, touching on what I've just really flagged up, but it's a sort of general question as to the extent to which some of these additional requirements may deter access to justice, in the sense of, will, for example, solicitors want to take on judicial review claims at the last minute in circumstances where one's acting very urgently, bearing in mind the expectations now of the court of what legal advisors need to do to before making applications. So either of you, Katherine or Rosie, whether you've got any reflections on that?
I suspect that's probably true, but I think if the court were thinking about this, and I suspect if Mr. Justice Swift were here, he would say, well, you know, it's your own fault if you decide to instruct solicitors at 11 a.m. on the final day, you know, and that people have got to behave in a reasonable way and get their ducks in a row. But I suspect that you're probably right at the sharp end. In extreme cases, there probably will be a small number of claims that don't end up being issued because of these additional risks and factors to be considered.
Thank you. Then another question's come our way, whether the requirement to agree a list of issues between the parties, to use the expression in the question, whether that's going to be a nightmare, because it's quite difficult sometimes to agree things between parties, particularly list of issues. They take some time, obviously, to agree list of issues. And would it potentially have a cost implication, i.e. increased costs by having to go through that process? I don't know whether you've got any. All I'd observe is, of course, that agreeing a list of issues is now something which is expected, obviously, in the higher courts. And so I think the administrative courts presumably takes a view that if it can be done there, it could be done in the administrative courts as well. But I don't know if either you, Rosie, perhaps got any reflections on that.
Well, it's also a matter that's commonly required in fast track trials and civil matters and things like that, and it's not new to litigation as a whole. And I suppose that if one was faced with an absolute impasse, you could always identify the defendant considers this to be an issue, the claimant does not. The claimant considers this to be an issue, and the defendant does not. And one could always identify issues that were not agreed. But I suspect you would have to be prepared for fairly intense judicial questioning as to why the party that disagreed that was an issue disagreed, and one would just have to be reasonable. And also one does have another 7 days to agree this list of issues after the defendant's filed its skeleton. And frankly, if the parties don't know what the issues are after you've both filed your skeletons, I think you're probably in a bit of trouble, aren't you?
Thank you. Yes. Well, another question has come in, which I actually do not know the answer to, so I'm hoping Rosie and Katherine will enlighten me as well. But does the filing of a hard copy require visiting the court in person, or can you post the hard copy? I probably should know the answer to that question, but does anyone know? We can probably look into it.
I think that I have no idea.
Might have to be one that's looked into. I know that there was guidance issued for the admin court in terms of COVID and how to get hard copy to the court, but I think that might have to be one where we post something on the website and let you know exactly what happens.
Yeah, we'll try and do that. And I think this is more of a question of practice of taking on clients, but someone has asked whether when taking clients on board, it may be worthwhile to require clients to provide brief sworn witness statements to offset the risks of some of the problems of bringing these claims in the time available. I suspect that's probably more a matter of how people choose to deal with their clients. It may not be particularly practicable to obtain sworn witness statements from clients, particularly in these sorts of circumstances at last minute. But again, Katherine and Rosie may have some views on that.
I mean, I think if you can do it, it's a good idea. I mean, whether or not it's sworn, I always find it quite helpful when I get instructions and I'm sent a draft witness statement, because it's just helpful. I can see what the evidence, what the facts being relied on are. But I think all of these requirements, you know, it's all very well to set them out in theory, but my experience of urgent applications is that they are really stressful, and sometimes the stakes are really high. You know, I might be instructed at 11 a.m. in the case of a family with children who are due to be booted out of their local authority accommodation that afternoon. So, you know, the risk of harm is very, very high, and there's just not time to jump through all of these loopholes. And so I think professional judgments have to be made, you know, how urgent. In a situation like what I've just described, I would have thought, you know, you're probably on fairly safe grounds to be making an urgent application, but practitioners just have to exercise their judgment in the circumstances.
Yeah, Katherine, we got time just for one more question, to answer one more question, which I think is directed principally at your presentation, but that regards the use of the M463 for an application that needs to be determined within 7 days. And the question is, do you mean that the application for immediate directions needs to be determined within 7 days rather than the application for permission or indeed the substantive application itself?
So I mean the application for immediate directions, or whatever the immediate application is. That's what you need to ask yourself. Does this need to be decided within a week or sooner? Not the underlying application for permission or the substantive application. And so I'd suggest, in fact, this is why I made the suggestion of thinking about whether actually you can solve the problem by applying for directions as a matter of urgency, which then sets things in motion for then a more substantive decision on, for example, an application for interim relief that you would get within the next couple of weeks or 3 weeks or whatever it may be in your particular case.
Well, thank you very much, Katherine, and Rosie as well. And in the spirit of the new practice direction, I'm going to bring this to an end pretty close to the 30-minute limit. And I hope everyone's found it useful. If you've got any further questions, do let us know. And as I said, the session itself will be available on the website, and we'll see if someone can find out about the posting of hard copy in the meantime. Many thanks to everyone, and I hope you enjoyed it. Thank you very much.